Alrighty, starting to go in here. All right, thank you for joining us for today's SBE on trademarks and copyrights. Hold on. My name is TJ Daniels, and I am the director of the Iowa Center's Women's Business Center. We are funded in part through a cooperative agreement with the SBA. Today, we have Tina Yenswatsky for the presentation, and I am going to go ahead and let her introduce herself and get the webinar started. Thank you so much for being here today, Tina.
All right, thank you, TJ, appreciate it. Hi, everyone. Thank you so much for joining us today. My name is Tina Yenswatsky. I am an intellectual property attorney with Frederickson and Byron. We are a general practice law firm. We have an office here in Des Moines, Iowa, but we are also a Midwest law firm, so the headquarters based in Minneapolis. We've got quite a few other offices around the US as well as office in Shanghai and Mexico as well. But I'm an intellectual property attorney. A lot of what I do in my daily work is around trademarks and patent work. But I also touch a little bit on other forms of intellectual property as well. So today we are going to focus more on trademarks versus copyrights. There is quite a bit of confusion sometimes out there with regard to the difference between trademarks versus copyrights. So today we're going to go into detail with some of these and explain how these are important for you as a small business owner and how you can protect yourself moving forward. So I'm going to go over just a very brief overview of just what intellectual property is. There are four main types of intellectual property. So the first two that we are going to talk about mainly today is trademarks. Trademarks, that is a source identifier. So that allows consumers to be able to identify a good or a service with a particular source. So we'll go into this in more detail in just a bit, but that's what trademarks are. The second one is copyrights, and these cover original works of authorship. So these are more, if you think more like creative works, so literary works, dramatic works, musicals, any artistic works, so music, books, poems, paintings, pictures. These are things that are covered by copyright. So even though trademark and copyright can be easily confused, they are actually quite different entities. So we'll make sure to distinguish those today in the presentation. The last two I'm not really going to talk much about today, but they are still forms of intellectual property. You might hear IP getting thrown around. So the third one is patents. That covers inventions. So that covers really any sort of invention that somebody comes up with, whether it's a actual widget or a mechanical item or a chemical composition. Those are covered by patents. And then trade secrets. These are things that derive some form of economic value from not being generally known to the public. So, for example, a good example of a trade secret is the ingredients for Coca-Cola. That ingredient formula for Coca-Cola is not generally known. You can reverse engineer it, but the actual formula and ingredient is kept as a trade secret. So why is IP important? Particularly as a business owner, you want to make sure that IP is being integrated into your business strategy. These can be really attractive to investors and buyers. A lot of times you'll hear, what's the status of your IP? What IP do you have? A lot of times you'll hear this if you watch Shark Tank, right? But it increases your leveraging power if you have good protection of your intellectual property, particularly if you're going through a merger and acquisitions. It's a property right that you have that can add value to your company's assets. So as long as you know where your IP is and how those are owned and protected, that gives you better leveraging power. It also deters other people from getting in your lane. Particularly as small business owners, you want to make sure that all the fruits of your labor is kept to yourself and nobody else can steal your idea or do something very similar. And so you want to make sure that you have your intellectual property protected. So one thing that I wanted to mention in terms of intellectual property, just about the outset, is if you are an employer, you want to make sure that you include some sort of IP assignment obligations within your employment agreements. That's kind of the first step to protect your IP. So for any employee that might be creating inventions, technology, or other types of IPs such as music or literary works or photos, if you want those to be kept with the company, you want to make sure that you have some sort of language in your assignment or in your employment agreements that indicates that the employee is going to automatically assign any sort of IP they create within the scope of their work to the company. So language that you want to use, for example, is I hereby assign any future IP work that I do, as opposed to saying I agree to assign any future IP. That seems like a really minor detail, but by saying I hereby assign, the date the employee signs the agreement, they have agreed to assign any future IP. By saying I agree to assign, this means that they haven't currently assigned anything, but they agree in the future to do so. And so this creates a problem, for example, if, heaven forbid, your employee ends up in an accident and isn't able to assign something in the future, but they have already created some work during their scope of business. You want to make sure that when they already created it at that time, it was already the company's property. And you want to do the same thing for third-party vendors and contractors as well, because a lot of IP, whoever is the one who creates it is actually the initial owner. And so if you are the company and you want the company to be the owner of the IP, you have to make sure that whoever is creating it is assigning it right away to the company. So that is one thing that is important for employers. Now, if you're an employee and you are maybe thinking about starting your own startup or creating your own business, but you haven't done so yet, you're still employed under another employer, you want to make sure that any work you are doing for your new startup or new idea, that you're keeping it for yourself. And so make sure that anything you are developing is off company time, without company resources of your current employer, so that your current employer doesn't have any arguments of saying, oh no, you created that when you were still employed with me. If you do not use any of their resources, you don't use their time, you don't use the knowledge you kind of develop solely from working at that company, then you have a better chance of saying, nope, this IP that I created separately from that is my own, and now I'm going to start my own company. So these are just things to kind of keep in mind from the outset. So I'm going to go into now trademarks and kind of explain more of what a trademark is, and then we'll go into copyrights. So what is a trademark? As I had mentioned earlier, a trademark is a source identifier. So it's used to help consumers identify and distinguish certain goods and services from those manufactured by others. So it helps to indicate the source of where that good or service is coming from to a consumer. So some examples, trademarks can be words, as you know, Apple for technology products, iPhones, phones, laptops, or IBM, that's another word that can be used as a trademark. It can be people names. These are harder to get a trademark for. However, if you become famous enough or well-known enough to consumers, you can trademark a name. So for example, Tommy Hilfiger. You can also trademark phrases or slogans. I didn't know this, but let's get ready to rumble. That is a slogan that is trademarked. You can trademark symbols, logos, for example, that Target symbol that can be trademarked. You can also target designs. So that Coca-Cola bottle there on the screen, the design of kind of the curvatures of the bottle, that can actually be kind of like a design, a trademark in some way to cover the design of the bottle. If it becomes well known enough, so when people see that shape of a bottle, even if they haven't seen the Coca-Cola label on it yet, they'll know, oh, that's Coca-Cola inside. I have an idea of where that source is coming from and what the taste is going to taste like. For example, you can also cover colors. This is a little harder to trademark, similar to the names. You have to develop sufficient sufficient notoriety in terms of people being able to identify a certain color with your good or service. So for example, T-Mobile, when you see a commercial, even without T-Mobile, the name coming on the screen and you see the pink with maybe a cell phone, people probably know right away, oh, this is the commercial for T-Mobile. So as I said, so it's being used as a source identifier so that people, when they see an advertisement, they know that this service or product is coming from which source. So it is a basic rundown of what a trademark is. There are different types of protection for trademarks. There's common law protection, there is a federal registration, and there's also international registration. So for common law protection, this actually is automatic. It's automatic once you start using a mark in commerce. So you don't have to register the trademark with the United States Patent and Trademark Office. These are rights that you get automatically just by starting to use the mark in commerce. However, the caveat is the protection of your rights in that trademark is only limited to the geographic area where that mark is used. So for example, if you are a restaurant in Iowa and you only have one restaurant here, you just service local Des Moines area, you likely would not be able to stop somebody from using a similar name to your restaurant or even the same name of your restaurant, for example, in California, because you only have a common law protection within the geographic area of where you actually use that mark in commerce. However, any trademarks that you use and that you have not registered yet, you can use that TM or SM symbol. TM just means trademark, SM means service mark. A lot of people just use TM. TM is supposed to be for goods and SM is supposed to be for services, but a lot of people use TM for everything. So even if you haven't registered, you can start using those terms, and it's probably a good thing to do so because it gives people on notice that, hey, this is my trademark, I'm using it as my trademark. So it gives people notice. However, be sure that you do not use that R with the circle around it if you have not gotten an actual federal registration on your trademark. So if you have not applied for a federal application yet, make sure that you are not using that R with the circle around it. So the next one, however, federal registration, this you can apply for, and myself as like a trademark attorney, we can help apply for your federal registration. Essentially what this provides you then is protection across the United States. So it gives you a much broader range of protection. It's not just where you're geographically working, but it can give you protection across the United States. This can also give you the right to bring a legal action against somebody for trademark infringement in a federal court. And this is when you can start using the R with the circle around it once it is actually registered. So what I mean by that is normally if you want a federal registration, we will file an application for you with the United States Patent and Trademark Office. An examiner will pick it up and look at the application, And if they find conflicting marks, like other marks that are either the same or might cause a likelihood of confusion with another third-party mark that already has a registration, they can basically reject your application, and then we would just have to work to either modify it or we might have to let it go. But there are other options we can do to address it once you get a rejection. However, once you kind of overcome all the rejections from the examiner, then the examiner will say, yep, it looks like this mark is clear for you to use and get a registration for. We allow your application, it's granted, and then that's when you get a registration. So once you get that final okay, that's when you can start using the R with the circle. Now, federal registration is only going to give you protection in the United States. So if you want also protection in other foreign countries, there are ways to do that as well. You can either file directly with an international trademark office in the country that you would like covered in. Otherwise, there's also something called the Madrid Protocol, where you can take your US application and essentially file a Madrid application and just extend it into the countries of interest that you want from that US application. So those are just kind of 3 different protections that you have in terms of your trademark. So what does a trademark actually give you? Well, it gives you exclusivity. So an owner can prohibit others from using the same or similar mark that would likely cause confusion among consumers regarding the source of the products or services that you are providing. So if you have a trademark to a word for example, ice cream services or an ice cream restaurant, somebody else could not utilize the same or similar mark to also sell ice cream or open a restaurant to serve ice cream or desserts, etc. Because you have that exclusivity then once you have a trademark. The length of protection for a trademark can theoretically be indefinite. The requirement is that you continue to use your trademark and that you're monitoring the use of your trademark. And so as long as you continue to use your trademark, you can continue getting an exclusive right to it. As long as you pay, there will be maintenance fees that you have to pay, as well as declarations that you have to file to say, hey, yep, I'm still using this mark in commerce. Here's the proof that I'm still using it. And it's basically you file some images or photographs of the mark slapped on the goods, or for example, with the service, the mark on a website showing that you are still providing these services under that mark. And that's just some proof for the trademark office to view. But theoretically, if you continue to use it, as long as you keep paying those maintenance fees, you can continue to have the exclusivity to that mark. Now let's talk a little bit about choosing a mark, because chances are when you start a small business, a lot of your first steps are, okay, what do I want my business to be named? What do I want consumers to see when they see my brand? So there are actually some rules in terms of which marks can even be registrable. And it depends on, again, likelihood of confusion with any third parties that already have their trademark filed, but it also depends on the strength of your mark. So we'll talk about the strength of your mark here in this next slide. So the stronger the mark, the greater your ability is to prevent others from using something similar. So here is the range of kind of how strong a mark is, the green being very strong. These are likely ones that you can get pretty good registration for, as long as there isn't a third party that already has something similar. The yellow is where it's possible you might get a registration, but you might need to have a little bit more proof before you can get a registration. If you're in the red, you cannot get registration at all. So let's go through the steps here. So the first one, fanciful. This is very strong. This is a very strong mark. And that essentially is a completely made up word. So for example, Adidas, that is a made up word, but It's being used for shoes and now for athletic wear. That is a very strong mark, because when people see the word Adidas, they don't have a lot of other Adidases to compare to, right? There's only really one Adidas because it's a completely made up word. So when people hear that, they know pretty quickly where that source is coming from, or what source the goods are coming from. Another example is Kodak. Kodak is not a real word. So when you hear Kodak, you know kind of right away what goods and services they're providing, cameras and things with photography, etc. Arbitrary is also a pretty strong, can be a strong mark. And this means it is a real word, but you are using it to sell goods and services that have nothing to do with the word. So for example, Apple for technology, that is obviously Apple is a real word, but you're using it to sell things like computers and phones and etc. And so when people see the brand Apple, but they see that it's on a phone, they know right away which source that phone is coming from. For example, it's not being used to sell apples itself. Apple is not being used to sell fruits. Apple is not being used for an apple orchard, because chances are for those types of goods, like if you were an apple orchard, it would start getting very confusing if a lot of other competitors also had to use the term Apple just to describe what kind of goods they're selling. So if there are a bunch of brands out there that have Apple in their name for an apple orchard, you could see how that can start getting very confusing to know where or what kind of service each is providing. Another example is BlackBerry for mobile devices. Obviously, BlackBerry is not selling actual BlackBerries, similar to Apple, it is selling mobile devices. Suggestive is still strong, just not as strong as the fanciful or arbitrary marks. So you can find a word or a mark that you can fit under the fanciful or arbitrary, that's great. But sometimes if you want it to maybe reflect a little bit more of what you're actually selling, suggestive is a category that is still pretty strong. So what that means is it's a word that kind of describes what goods and services you are selling, but it needs a little extra bit of creativity to get there. So for example, copper tone for sunblock lotion, it's suggesting that if you use sunblock lotion, your skin will get this nice copper tone. For example, then Camelback for water bottles, even though I think this is technically a myth that camels' humps hold water, but that's kind of what they're trying to suggest here is the back of a camel, the hump, it's being used to sell water bottles. So it's suggesting that it holds water. So that's kind of the suggestive category. Where I do see a lot of marks ending up initially when companies first try to come up with names is it ends up in the descriptive section, and descriptive is just not as strong, and you actually can't get a registration right away on just a merely descriptive mark unless you show something called secondary meaning. Secondary meaning, kind of what I talked about earlier in the slide with regard to names and colors. It means that essentially a consumer just hearing your mark or your name, you have enough recognition that a consumer will see it and know what types of goods and services you are providing, because you have developed that kind of you're that well known now because you have used the mark for so long, or it becomes very popular, for example. But the reason why descriptive is not as strong is because, again, it can cause a lot of confusion in terms of what goods or what source your goods are coming from. So for example, sweet and chewy for caramel. If you're selling caramel and it's called sweet and chewy, they are probably, the trademark office is likely going to reject it for saying that is merely descriptive. You're just merely describing what goods you're selling. Another example is creamy whip for whipped topping. You can probably imagine if you were at the grocery store going down the aisle where they sell whipped topping and you see a variety of brands such as creamy whip, whipped cream, cream and whip, you know, if it's just kind of describing what the whip topping is, it can be very confusing when you see all those brands exactly. Okay, what source is this one coming from? What is this one going to taste like? Are they all the same? Are they different? You know, they can get very confusing. So that's why descriptive marks are not as strong. The last one is generic, and you cannot get a registered trademark at all for a generic mark. Generic is when you are essentially using the word itself to sell the goods that the word is saying. So for example, you could not get a trademark to bicycle if you are just selling bicycles. And the reason for that is because the government doesn't want to give anybody an exclusive right to use a word that just it has to be used to just merely describe what goods somebody is selling. So that would be, yeah, so they wouldn't allow you to get a registration on bicycle. The other example of generic is you maybe have heard genericizing marks. And this is unfortunately when the mark becomes so well known that people start using that mark to describe any brand of that good. So for example, insulated bottles, the brand name Thermos, it just became so well known that now a lot of people, regardless of whether or not the bottle they're holding is actually a thermos or not, they'll call it a thermos anyway, right? Oh, can you pass me my thermos? Even if it's not the Thermos brand. And that's when it becomes genericized because it's no longer being used to identify a source of where that insulated bottle is coming from, because you're not using it to say it's coming from Thermos. You're just saying, pass me my Thermos, because you're now using it just to identify the good itself. So a lot of companies do, once they start getting towards that end, kind of like Xerox for photocopying. Oh, can you Xerox this for me? Or Velcro, that is a big one, where they want to prevent them from becoming genericized. A lot of companies will kind of put commercials out there to try and tell people, nope, don't use it in a way that is going to, you know, essentially make it genericized. So those are kind of just the range of the trademarks. I would say if you can find it in the green, that is great. If you're in the yellow, there are ways to get you in the green. And then if you're in the red, you cannot get a registration. All right, so there are different formats when you file a trademark application. So I wanted to bring this up because a lot of people I see when they do file their trademark application, they go directly to just filing the image or logo that you come up with. But sometimes that might not give you the broadest protection. And so the first one that I usually recommend if you want kind of broader protection is just a standard character mark. You can see that here on the screen. It's the Coca-Cola all in caps. And essentially what that means is this trademark application that you file will cover any font, any color, really any design of Coca-Cola. As long as it says Coca-Cola, that is covered in your application. So that will definitely give you the broadest protection. Now, if you want kind of secondary protection to further cover, or if you have a logo that doesn't have words in it, you can then also file a special form format. So for example, this Coca-Cola has a design to it. If you file this application, however, the protection you have is limited to the image that you submit. So for this Coca-Cola, if you had moved Coca and then Cola underneath, even though it has the same font, that will not be covered since the image you submitted is Coca-Cola all on one line. Also, you can file something like this Nike one here where it's both words and a symbol. You can see here there's actually, it's very small, but you can see there's the two R's in the circles. And it looks like because Nike has also protected both Nike, the word, and the symbol itself. And so having both of those protected, they can put them together and they would still be protected. For example, one like the McDonald's arc that does not have words in it, it's just a symbol, but that can also be protected. So I would recommend before you file a trademark application to get a trademark search done. And that search doesn't have to be very comprehensive, even if it's just a quick preliminary search by a trademark attorney. They can look at the database of all trademarks that are already currently federally registered, and they can see if there might be any conflicting marks or marks that might prevent you from getting a registration. And this is important to do because if you find out early enough, that can save you a lot of time and money from building out your store or starting to use this mark on your goods and services, and starting to build this rapport with your client base. And it would just be very unfortunate if later down the road you find out you can't even get a registration because there's already somebody else out there who is using a similar mark with similar goods and services. Now, I do mention this because it is dependent on likelihood of confusion with regard to your goods and services. So what I mean is there could be multiple companies that have a trademark registration to the exact same word. That is possible, as long as the goods and services they sell are far enough apart that consumers wouldn't confuse the two of them together. So for example, Dove. Dove sells chocolates. They are also trademarked for ice cream bars. But there is also the company Dove that also sells soaps. And I don't think anybody really has any confusion in terms of, oh, I think the company that makes the ice cream bars is the same that makes my soap that I use. And so it is possible to get a registration on the same word, but in different classes of goods and services. So this is why it's important for you to reach out to a trademark attorney who is able to kind of do this detailed search to determine, okay, even though maybe somebody has a similar name, it's in a completely different goods and services, so you likely would be fine. The trademark office will also look at what it looks like, what it sounds like, and it will also look at translations as well. So even if your mark might sound or look a lot different than another mark, but if it translates to the same word, a trademark office could still deny that application. So this is why it's very important to consult a trademark attorney, but you can also kind of do your own individual search as well. I put there's two different links that you can go to get to the same page, but essentially it's the database that you can go to search third-party marks that are already registered or applied for, and you can see if there are marks that are similar to yours before you start commercializing. So the next question might be, okay, so all this information I know about trademarks now, when should I file the application, especially for the federal registration? As I mentioned, common law rights you get automatically, but for federal registration, you will need to file an application. So there are two types of applications. The first is an intent to use application. And this means that you have not started using your mark in commerce quite yet, but you have a bona fide intention to do so. So you cannot just file a trademark application on any and all words just to kind of reserve it for yourself just in case. You have to have an actual intention to do so. It's just that you haven't quite gotten to commercialization yet. So this is a good option to use, however, if you know what mark you want, because it can help you obtain an earlier filing date than a possible competitor down the road. For trademark applications, they look at what is the date that you file your application. Generally, they look at what date you file your application. And so if you can have an earlier filing date, then for a competitor that comes later down the road, even if it's before you start actually commercializing it, you might still get rights because you filed first. So that's why intent to use application sometimes is very useful if you know what mark you want to use, you just haven't quite gotten to commercialization yet. But there is a time limit then to start using your mark in commerce. So if you remember when I was talking through kind of the pathway of getting a registration. You file the application, it goes through examination, and then the examiner eventually, hopefully, allows your mark and says, okay, yep, you can get an allowable mark. At that point, that's when you have then 6 months to prove to the trademark office, yep, I have now started using this mark in commerce. There are extensions available, so you're not limited to just that 6 months, but there is some time limit there in terms of when you file the intent to use application and when you need to start actually using your mark. Otherwise, if you have already started using your mark, you can file just a use-based application, and you can file that really anytime after you start using your mark in commerce. You will have to submit something called a specimen, which is essentially just proof that you are actually using it on the goods and services that you say you are. So for goods, it's just if you have your logo or your brand slapped on top on the packaging or on the good itself, that is enough proof. Otherwise, for services, normally that can be a web page that has your mark on the top corner and says what kind of services you're providing. That will work as proof. So that's kind of the trademark process. There's a lot in there, but those are kind of the high-level basics of what you need to know for trademarks. If you have any questions on that, feel free to let me know at the end of the webinar, and I'll be happy to answer those questions. So hopefully that gave you a good idea of what trademarks are. They're source identifiers. You see them as kind of brands. They're always connected to a good or service that you are providing in commerce. Now we're going to switch to copyrights, which is quite different. So copyright, it protects creative expression of an idea fixed in a tangible medium. So it does not protect things like ideas or procedures or systems, discoveries. A lot of that fits more under the patent side of things. But what it does cover is stuff like music, books, photographs, jewelry, fabric designs. That is what copyrights cover. So I have kind of 2 examples here is an artist who paints the Iowa State Capitol. They have a copyright in the painting they make. So each of the individual authors or artists who drew these pictures, they have a copyright in this photo or in this painting. Once that paint touches the canvas, that is already started to get protected by copyright. However, the artist cannot prevent other artists from also painting the Iowa State Capitol, right? So, just because you have a copyright to the image on the left does not prevent somebody or another artist from creating the image to the right. So trademarks is protecting the brand, whereas copyright is protecting the creative content that is created by authors. So what is the scope of protection if you have a copyright? Well, it gives the owner, so the artist, the author, the exclusive right to copy and reproduce that work, publish and distribute it, display or perform it, and create derivative works. And what derivative works means is works that modify the work just a little bit based on the original copyrighted work. So all of those things are exclusive to the owner. The length of protection for this is if it's a work created after January 1st of 1978, if it's just an individual, it's the life of the author plus 70 more years. So once the author passes away and after 70 years has passed, then their work is what they call in the public domain. So anybody can use copyrighted material that is in the public domain. If it's a work made for hire, which means it's more on the corporate side of things, includes works created by an employee within the course of their employment. This is 95 years from publication or 120 years from the creation of the work, whichever expires first. So just kind of different timelines that you don't necessarily need to put in your memory right now, but just so you have a good idea of how long the protection of a copyright is. As I mentioned with trademarks, that can technically be indefinite as long as you continue renewing it. But with copyrights, there is an expiration date to your protection. Copyright protection is automatic. So once that work is fixed in a tangible medium, so what that means is once the words for a book, end up on the paper, once the music gets written, and once the music gets written out, once the painting touches the canvas, that already starts the protection for the copyright. Registration is not required. So if you don't register your work with the Copyright Office, you do start having rights in the copyrighted work itself. It's just that having that registration is required for you to sue for copyright infringement. On the flip side, if you are looking at other people's copyrighted material, just because you don't see that C with the circle around it, the copyright symbol, this does not mean that it is not protected by copyright. So the best kind of rule of thumb is to always assume that a work of authorship is protected by copyright, and that you cannot use it without permission unless it's in the public domain. So I'll kind of go into some examples here. One of the biggest things I think is online images. When you're looking at, for example, just searching Google images for an image that maybe you want to put on your website, or an image that you want to put in like a brochure or something like that, you have to make sure that you have permission to use that image before you actually use it. So if you find an image on Google, that does not mean you can use it. You have to complete kind of a copyright analysis. So first is determine, okay, is this image under copyright? Most times than not, it's going to be yes. Unless you find that a really, really, really old image, it's possible that it is in the public domain. Or we'll talk about this later as well, but if it's like a stock image, that is normally, in the public domain as well. So determine if the image is under a copyright. The second, if it is, and there's no license attached to it, you need permission before you can use it. If you're looking on Google Images, it's kind of nice now. They sometimes tell you if there's a license attached, or if like the name of who the author is. And sometimes you can find their contact information to then ask them for permission to use that image. So just here are some ways to kind of limit your risk in terms of copyright infringement. If you find a copy of a photo or an image that you want to use, a lot of times if you can share a link to it rather than, if you can find the link to it rather than copy and pasting it, that is sometimes better, because the person who wants to go see it can just click to the link and go to the original source to view it. Otherwise, the best way is always use photos and images that you have taken or created yourself. And note, if it's a photo taken through your employment, it likely belongs to your employer. So be aware of that as well. But things that you create yourself, you are then the author of that photo, and you can decide how you want that to be used. As I had mentioned earlier, there are things called Creative Commons licensed images. So there are some images that come with licenses. And essentially what you have to do is just read the terms and conditions for how you can use the image. And then sometimes you need to provide some sort of attribution to them. But a lot of times they'll say things like, you can use this for, or it will limit what you can use the image for. So in terms of like commercial use, they'll provide some limits to how you can use that. The other way is you can purchase images from stock photo agencies. There are sometimes also license limits on the use, but a lot of these stock photo agencies you can go to actually purchase photos for, and then you can use it in ways that, as long as it doesn't have any limitation, you can then use it in any way you like. So those are kind of just tips in terms of using images and photos, which are copyright protected. And I think it's really easy for someone to commit copyright infringement unintentionally. And so these are just some important things to make note of. So the last thing I have for copyrights is it is a very gray area in terms of what is copyrighted, what can I do with a copyrighted work, how much can I change the original work to then not be copyright infringement. There's just, it's a very gray area. So I would say if you have any questions, be sure to reach out to a copyright attorney if you have questions. If you have them, feel free to reach out to me. I'll send you to the right attorney that does more of the copyright work here at Frederickson, but it's important for you to make sure that you're not committing in any sort of infringement, because it could happen unintentionally, but that is still infringement. So it's important to keep note of that. And then if you believe one of your copyrighted works are being infringed by someone else, an attorney can also help you draft what is called a cease and desist letter to that party to, essentially it's that first step before you have to go into full-blown litigation, because it's extremely expensive, but just a simple letter that says, hey, this is copyrighted material owned by us. You are using it in inappropriate way, and so you are infringing on our copyright, etc. And so that's just kind of a quick letter to kind of put them on notice if you do have some sort of concern in terms of other third parties infringing on your copyright. So that is a very, very quick overview of copyrights as well. But I want to make sure I have some time here for questions if there are any. Here's just a disclaimer that anything I provide today is not legal advice, but it's more for just educational purposes. And if you have any questions, here's my contact info. Feel free to call or email with any questions that you have. And thank you all again for your time.
Thank you so much, Tina.
Yeah.
We had one question so far. What should I expect to pay a trademark attorney to get a name trademarked?
Yeah, that's a very good question. So a lot of firms will have different prices, but so, feel free to always kind of call many different law firms just to see what recommendations they have and what their costs are. Normally for that first call is no charge. So that's always a good way to kind of get to know different attorneys in the area, see who you kind of connect with, who you want to work with. But I would say, so for the government fees, these are non-negotiable. These are paid to the trademark office. It is dependent on how many classes of goods and services you have in your application. So for example, like Nike may have shoes, and that's probably in one class, and then they probably have like t-shirts and long sleeve shirts and pants in another class. But they probably also have, I don't know, maybe like basketballs or, so these are all different classes of goods and services. They can kind of put them in categories. So it depends on how many you have. I would say a lot of times you can fit a lot of what you're doing in one or two classes, but the government fees are about $350 per class. And then I would say plus attorney's fees, usually that runs about, I would say, like 500 to 600 per class. And then per added class, a lot of firms will have maybe some discounts. So they might have like a $200 for each additional class. So I would say set aside about $1,000 to $1,500 for your trademark application if you have about 1 to 2 classes of goods and services.
Perfect. Okay, here's another question. Kind of long, so bear with me.
Okay.
For our business, we create a lot of one-of-a-kind events specific for our company. For example, a puzzle competition with specific features and rules that don't currently exist elsewhere. Is there a way to protect that work to prevent people from copying it? And along the same lines, we also brand a lot of these events separate from our company brand. Should we try to protect this event branding as well?
Okay, yeah, so couple things there. The first question in terms of the instructions to the games, if I'm understanding that question correctly, and the puzzles and types of things, if it's written down on paper, those instructions can be protected by copyright. And so that would prevent other people from then copying those same instructions. So that is kind of the protection you would have for the puzzles and the games. In terms of branding for the actual event, that's possible for you to then get a trademark on just the event brand name itself. It would kind of depend on what goods and services you're providing in commerce. If you're, selling tickets for this event, that might be something that you can then cover under a trademark for that separate event. That would be fine as well. If you're selling goods with this event as well, it's possible that you can also cover those goods under that trademark as well for the event. Yeah.
Perfect. Here is another question. How long does it typically take to have a trademark or copyright granted?
So for a trademark, especially with COVID, the length of time that's taken for the examiner to actually pick up an application has extended just due to the number of people filing trademarks over COVID. So right now we're looking at, once we file an application, we normally don't hear from the trademark office until about, I would say, 8 to 12 months later. If everything's good with your trademark, then usually you'll get a grant pretty soon after that. And then, I would say probably about a year and 2 months or so. But if there are some concerns with the mark, for example, if there are other marks that are already out there that might be something similar, then the attorney will have to view those rejections and provide arguments and written arguments against it. And so that will take up a little bit more time, cost as well. And so it kind of just depends on the complexity of the rejection. But I would say generally you're looking at a year to, I would say no more than 2 years to get a trademark registration. This is also where it really helps to have that preliminary search beforehand, so you kind of know what rejections you might see. For copyright, the copyright doesn't really, they don't look at what other third parties have. Whatever you kind of submit is your copyright. So that does not take very long in terms of getting, it's just a matter of kind of filling out the form and paying the fees to file the copyright.
All right. Please put any additional questions you may have in the chat. Tina, I always ask this to all the speakers. What is one piece of information that you want our clients to get from this presentation today?
Oh, just one piece.
Two. I'll give you two now.
Oh man, well, so one of them is just be so mindful of copyrighted material. I know it's so easy to unintentionally commit copyright infringement. I remember when I went through my copyright class during law school, I came out feeling like I couldn't share anything. I couldn't do anything because I was like, oh my gosh, I'm committing copyright infringement. But no, it's just be mindful, especially when you're using other people's photos or images or copyrighted works. That it also includes music as well. Like for example, like restaurants, when they play music in the restaurants, you technically have to pay some sort of license fee to play that music. So just because you own, or just because you have an account with Pandora or Spotify or YouTube, that doesn't mean that you can just play that in your restaurant. A lot of personal things, that's fine, but once you do it for commercial purposes, that's when the government starts looking at it and when people get more concerned about copyright infringement. So just be aware of that, I would say, is one of the biggest things. And then on the trademark side, is it breaks my heart when I work with a client who has been, working with a certain brand for years and developing a really good rapport with their clients. A lot of clients know their brand because they've just been doing such a good job and doing it for years. But we find out that somebody else is using the same thing, maybe a few states away, and you didn't know about it. And then you can't get a registration on your mark. It makes me really sad to have to break that news to them. So, if you have the ability, I know it's a big cost, but if you have the ability to even just do a preliminary search to see, okay, I'm interested in using this name. Can you just check if that's okay for us to continue using? We don't have to file the trademark federal registration application now, but I just want to make sure, I can start using this mark and maybe file down the road. That is going to be like maybe more like a $500 cost, or even less if it's just for like one class. An attorney can do that search for you and kind of give you oh, nope, somebody else is already doing that. They've been using it for 5 years. They've been using it for 10 years, just something like that, just to get a little bit of knowledge beforehand is going to help, I think, help a lot down the road, so that you don't run into a situation where you just can't get your trademark protected.
Okay, that is perfect. A quick question that I just thought of. As a small business owner, if you know something of yours was stolen, are you able to send the other person or business a cease and desist letter, or does that have to come from an attorney?
Yeah. You could technically write one. I would say it sometimes seems a little bit, it's a little bit more like demanding if you get it from an attorney, right? Because then it makes them feel a little bit like, oh, they're serious about this, I need to stop using it, right? But you can always reach out to them and say, even if it's not a formal cease and desist, just to say, hey, I notice you're using my copyright, please stop, otherwise I will use legal action. You could use the like, oh, I'll reach out to an attorney if you don't stop using. So you can certainly contact the other third party if you know of them committing some sort of infringement against your product. That's a good question. Yeah.
Perfect. Thank you so much for joining us today and providing such valuable information. Thank you for the clients for attending and asking such great questions. Next Monday, we have another SBE webinar on obtaining a brick and mortar. Please join us and check out all the other events at theiowacenter.org. Thank you again for attending. Have a great day.